And then here, let's get to this. So prosecutorial immunity, guys, is pretty much, you guys have heard of qualified immunity. And I'm not an expert in these terms. I've just read a lot. I've tried to watch any cases that come up that challenge prosecutorial immunity. We usually think of qualified immunity when we think of police and detective work. And qualified immunity, it's like, dang, you can lie. You can mess up reports, mishandle evidence, behave badly on the job, probably still be protected in broad capacities in a lot of circumstances. Prosecutorial immunity is even stronger for a prosecutor. It's essentially, I think the case that it came from, the Supreme Court case it came from, is from back in the 70s. Back then it was like blanket absolute immunity for prosecutors. You can falsify testimony. You can mishandle evidence. You can hide evidence. And you'll be protected from lawsuits that would bring damages against you. Right? That's different than if, your prosecutors are attorneys. That's different than the bar coming from your bar card. But it's protection from damages. So an individual can't just come sue you and think they have a good chance of going anywhere with that suit. Probably won't even make it to a hearing date. Right? So when we talk about immunity, it deals with someone bringing a lawsuit against you for the damages. Now, prosecutorial immunity, even though it's pretty absolute, that only applies when a prosecutor is acting within the capacity of their role as an advocate for the prosecution of a relevant case. If they step outside of that role and they're doing something, then prosecutorial immunity might not apply, probably shouldn't apply. But what's the problem with that? When a prosecutor is no longer acting as a prosecutor, if they're doing something that treats them more like a detective or an investigator, well, then they get the second umbrella of qualified immunity helping to shield them. So even though they're not technically, say for example, what Hilton was doing with Woody, maybe there's an argument to be made there that what she was doing was less in a prosecutorial capacity and more of a detective capacity. Well, great. She might not have prosecutorial immunity for the things she's doing in those interactions, but she'll have qualified immunity. So even though there's this big main case from the 70s that says, yep, absolute immunity, but only while you're acting as an advocate for a prosecution. If you step outside that, you don't have that absolute immunity. Well, you kind of almost do. Because most prosecutors crossing the line are still kind of doing so acting as a police officer or detective, trying to investigate. So, doing the detective work. There was a recent case, and I had pulled up an article about it. I'm not actually familiar with the article itself, but this is the case I had in mind. Because when we have something that's stemming from a Supreme Court case, it has to change through case law, which can be a slow, tiring process. And so this is a blind read for this article, but it is about the case I'm thinking about fairly recently from the Fifth Circuit. So no immunity for prosecutor accused of fabricating evidence in death row case. For the second time, a federal appeals court has denied prosecutorial immunity to a Louisiana district attorney accused of falsifying testimony. So that's the issue, was falsifying testimony that sent the man to death row. And this is the case I was talking about. Created by the U.S. Supreme Court in 1976, federal courts have granted prosecutorial immunity. Make this bigger. Well, it kind of sucks. Well, let me put this into reader mode and see if this is better. There we go. So created by the Supreme Court in 1976, federal courts have granted prosecutorial immunity to prosecutors accused of falsifying evidence, coercing witnesses, and hiding evidence showing defendants' innocence, among other unconscionable acts. The only exception to this otherwise absolute immunity is when prosecutors' misdeeds are not connected to their role as prosecutor, such as when they act as an investigator or cop. And this has always been the case, stemming back from this. I wish they gave us the name here. Maybe they tell us if I click it. Okay, that's why I don't remember the name. Imbler versus Pachtman. That high barrier makes the decisions by the Fifth Court. So this is that recent thing we're going to talk about. The Fifth U.S. Circuit Court of Appeals, all the more remarkable. Wearry v. Foster strikes a major blow against government immunity across the Fifth Circuit, which governs Louisiana, Mississippi, and Texas. The case stems from the brutal killing of Eric Walber, a high school honors student who was robbed, beaten, and run over with his own car while out delivering pizza in Livingston Parish. So in Louisiana, parishes are like counties. Louisiana back in 1998. For years, the case went unsolved. But in 2000, a jailhouse informant implicated Michael Wearry. Though there was no direct physical evidence tying Wearry to the crime, he was convicted of murder and sentenced to death in 2002. While on death row, Wearry's attorneys discovered that the prosecution had withheld significant evidence. So Wearry threw a legal Hail Mary and urged the U.S. Supreme Court to hear his case. It worked. In 2016, the High Court tossed Wearry's conviction and ordered a new trial, declaring that the prosecution's failure to disclose material evidence violated Wearry's due process rights, and the state's case, which resembled a house of cards, left room for reasonable doubt. So we don't have confidence in this outcome. So the High Court here is deciding we don't think prosecutorial immunity protects this conviction. But what else? As Wearry awaited his second trial, he filed a civil rights lawsuit. So this is where we actually are trying to bring damages against prosecutors, right? So here with the Supreme Court, this is just about winning a retrial and dealing with the conviction. It's not exactly dealing with any pushback on the concept, the protection of prosecutorial immunity. Because remember, that's a protection against someone bringing damages against you, lawsuits to sue you for what you did to them. So now we're going to get into something that actually attacks the protection of prosecutorial immunity. So as Wearry awaited his second trial, he filed a civil rights lawsuit against District Attorney Scott Perillo and Livingston Parish Sheriff's Detective Marlon Foster, claiming the two men fabricated evidence by coercing false testimony from a minor. And you got three things wrong here, right? Fabricating evidence and coercing testimony from a minor. According to Wearry, Perillo and Foster repeatedly intimidated an adolescent boy, who was 10 at the time of the murder, to testify that he saw Wearry at the crime scene, a fabricated narrative that would help send Wearry to death row. A district court judge sided with Wearry in 2019, a decision later upheld by the Fifth Circuit in May. So, district court sided with Wearry in this case. If it had to be brought up to the Fifth Circuit Court, my guess is that these parties appealed it, right? So we have the district attorney and the sheriff fighting to appeal this win that was handed to Wearry. They take it up to the Fifth Circuit Court. The Court of Appeals drew a firm line between the advocatory function of organizing, evaluating, and presenting evidence, and the separate investigatory function of gathering or acquiring evidence. So this would be prosecutor advocacy. This would be investigators or detective work. Prosecutorial immunity, the court emphasized, only extends to the former, this capacity, this role. Explaining what activities are advocatory versus investigatory, the Fifth Circuit noted that when a prosecutor joins police in the initial gathering of evidence in the field, as a district attorney did here, he acts only in an investigatory role for which absolute immunity is not warranted. So in this instance, Wearry was allowed to bring damages via civil lawsuits against these two parties. Only Judge James Ho, the hilarious last name, dissented from the Fifth Circuit's decision. He would have ruled against Wearry, but the judge penned a remarkable, doubting opinion where he scathingly attacked the unholy trinity of immunity doctrines. So this decision, he probably had a different reason, a specific argument why he dissented, but in his dissent, he still attacked the unholy trinity of immunity doctrines. So even the dissent was like, I still don't agree with absolute immunity. That's crap. So prosecutorial immunity, qualified immunity, and municipal immunity. If you guys have watched any of my content about Johnson City Police Department and the alleged cover-up that they engage in to protect a serial rapist, the city is leaning on municipal immunity. So, Jane Does that are trying to sue the city and members of the police force, one of their arguments is, well, we're the municipality. You can't sue both because one is operating in the capacity of the other. So, as an employee of the city. So same type of concept, but rather than being a police officer or investigator, it could be anybody employed by the municipality. Noting how vigorously both the Supreme Court and the Fifth Circuit have repeatedly affirmed and dutifully applied prosecutorial immunity, even in the face of disturbing claims of prosecutorial misconduct, Ho felt duty-bound to follow that precedent. So that was his decision. He's like, I hate it, I hate it, I hate it, but I feel like I have to follow the law of the land. Nevertheless, he was doubtful that those prior decisions were correctly decided, offering a compelling, full-throated argument for why the doctrine of prosecutorial immunity appears to be mistaken. So Ho recounts that when Congress passed the Civil Rights Act in 1871 to allow civil rights lawsuits against local and state officials, there were arguably only two available immunities that could have applied to modern prosecutors: quasi-judicial immunity and defamation immunity. The latter only covered defamation claims, which aren't present in Wearry's case, while the former could be defeated by a showing of malice. And that is exactly what Wearry has alleged here: a malicious effort to falsify witness testimony against him in a capital murder trial. Ho even cited a concurrence by the late Justice Antonin Scalia, who declared that there was, of course, no such thing as absolute prosecutorial immunity when this was enacted, when the Civil Rights Act was enacted in 1871. So he's agreeing with the Supreme Court justice here, who made an argument at some point that because this existed, this 1976 case that really established prosecutorial immunity as absolute immunity was incorrectly decided in the first place. It never should have been a thing. And wait, where am I? Okay, we're here. So, and that is exactly what Wearry has alleged here: a malicious effort to falsify witness testimony against him in a capital murder trial. I still feel like I'm in the wrong spot, but whatever. He cites Scalia. We're here. Wearry's complaint plainly alleges a bad faith, malicious violation of his constitutional rights, Ho wrote. That should be enough under the text and original understanding of 1983 to proceed to the merits. Unfortunately, in Ho's view, modern Supreme Court precedent on prosecutorial immunity kills Wearry's suit. And if prosecutorial immunity didn't do the job, then qualified immunity presumably would. Because remember, that's like the second umbrella that's pretty much just as broad. Worthy civil rights claims are often never brought to trial, Ho lamented. So he's angry about this while he's writing this dissent. Because an unholy trinity of legal doctrines, including qualified immunity and prosecutorial immunity, frequently conspires to turn winnable claims into losing ones. Although Congress has the power to abolish these doctrines, it shouldn't have to, since they were created whole cloth by the U.S. Supreme Court. In short, there is a problem of the court. This is a problem of the court's own making. Perillo and Foster's family filed for an en banc review. In late October, the entire court of the Fifth Circuit voted 9-7 against rehearing the case. So the decision's going to stand, which let the earlier decision from the Fifth Circuit stand. Once again, Ho wrote an opinion that affirmed his belief that absolute prosecutorial immunity is inconsistent with the text and original understanding of Section 1983, the Civil Rights Act, concurring with the decision against rehearing. Ho argued that public officials deserve some measure of deference when facing life and death decisions. By contrast, when public officials make the deliberate and considered decision to trample on a citizen's constitutional rights, they deserve to be held accountable, Ho argued. Wearry's case falls squarely in the deliberate violation bucket. Thanks to the Fifth Circuit, Wearry's lawsuit can finally move forward to the merits to determine whether Perillo really did fabricate evidence. As for Wearry himself, he's still behind bars for another few years, having accepted a plea deal before his second trial began. He pled guilty to manslaughter and received a 25-year prison sentence, but with credit for the many years he's already served. The en banc Fifth Circuit has now issued the case's third ruling that prosecutorial immunity does not protect officials from responsibility for such conduct. MacArthur Justice Center attorney Eric Foley told The Advocate, "We look forward to moving this case into discovery and toward a trial to hold these men accountable." Now, this is the article we just read, but there we go. So this all stemmed because we are talking about prosecutorial immunity, and the problem is we have this, and you see in that dissent. You see it in that dissent. We want to hold on to what the Supreme Court has decided back in 1976, even though we think that was a bad decision. It was incorrectly decided. And other Supreme Court justices like Antonin Scalia have tried to express that they disagree with that, but there hasn't been enough yet to officially overturn that long-standing decision. And this is a small pick away at it, this Fifth Circuit case. And I believe there's another one in Maryland, I think I read, that was also quite recent. But that's the process to challenge something like this. That's how it works. And we see we're going all the way back to a code that was enacted in the 1800s, and then a Supreme Court case back in the 70s. That's somebody's entire lifetime. Like, that's how long the change takes. So, appreciate you all for going down this rabbit hole about prosecutorial immunity. Hope that was a good summary. And Eric, thanks so much for getting the conversation going. You guys share your thoughts. Raymond Rohrer says, oh, there we go. Look, yeah. And I have fun being able to talk about these concepts. Because there was a point in time back in, 2022 where I was like, why does this immunity exist? This is crazy. And then I went down this rabbit hole that we just went down together just now.